Hello friends! On today's video we're going to tackle one of the most controversial, misunderstood, and emotionally charged questions in divorce. And that is, can my child choose which parent to live with during a divorce? I tell you, moms ask me this question, dads ask me this question, kids, if they could, they'd ask me this question. Well, let's get to the truth with a side of insight and just enough spice to make it interesting. We're going to give you the answer right after the break. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, without further ado, the answer is Florida law does not give children the legal right to choose where they want to live during a divorce. Not at age 12, not at age 14, not even if they have a learner's permit and can drive their parents' car under parental supervision. In Florida, there is no magic age in which children get to decide where they want to live during a divorce. But, and it's a big one, the courts can consider a child's preference as one of the enumerated factors under Florida Statute 61.13 when contemplating all of the factors. And the key phrase is that the court may consider it. And we're going to explain a little bit more now. So some of you may be asking, well, what does a court actually look at when considering the express preference of a child in terms of where they want to live during a divorce? The child's age, maturity, and the reasoning behind the preference is probably going to carry the most weight. For instance, a 16-year-old who says, I want to live at mom's house because she doesn't have a curfew at night, well, that may not be very persuasive. However, a 13-year-old who says that dad is always home and helps me with my homework and takes me to my extracurricular activities while mom is always traveling during the week, that might actually carry more weight. Judges are looking for certain cues. Is the child being pressured or one of the parents putting pressure? You can look at text messages or correspondence between that parent and the child to see if that's true. Is the child trying to manipulate the situation? I know, all of us think that our children are so innocent, but have you ever heard of a teenager or a tween trying to manipulate a situation so that the end result is what they want or what they desire the most? I'm sure a lot of you can think of examples of that. Or is the express preference sincere, thoughtful, and comes from independent thinking? Now, let's talk about how the child's preference in terms of where they would like to live is expressed in court. And before anyone asks, no, they don't just show up to court, raise their right hand, and start spouting off in front of everybody where they'd like to live. It doesn't work that way. As a matter of fact, it is very rare that a child or children will be called to testify in front of their parents, in front of the attorneys, and whoever's in the court to express their preference. Their preference, or the children's preference, is usually obtained through proxies. For instance, if there's a court-appointed guardian ad litem, the guardian ad litem will generate a report, and in that report, oftentimes, it will explain what the child's preference is in terms of the living situation. Or if the minor child or children have a therapist assigned to them. Also, if there's a social investigation report, the investigative report will articulate where the minor child or children would like to live according to their preference. A more uncommon method, and I say uncommon, but I've seen it happen quite a few times, is when a court will take the matters into its own hands to determine the preference of the child and conduct a judicial interview. This is called an in-camera interview of the minor child. Essentially, the court will step down from the bench. The judge, he or she, will go to chambers with the child. Oftentimes, it's mandated that a court reporter be present so that the parties will be aware of what transpired in chambers, and the court will question the child. This obviously depends on the child's age, maturity, and whether or not the court thinks that they can handle the questions or answer truthfully. During this interview, the court will ask numerous questions about custody, parental responsibility, and eventually will ask the child about their preference. In this type of situation, you can imagine that the preference of the child may carry significant weight. Before we move on, let's talk about a common misperception as well as some pitfalls. One of the most common misperceptions is if a child comes home and says, you know what, I hate that other parent. Boom, you're automatically going to win your case against that other parent. Nuh-uh, wrong, not so fast. Remember that family courts never make their decision based on emotion or one child's allegiance for one parent against the other parent. The courts will always guide themselves by the best interest of the child, even if that doesn't comport with the child's preference. Also, remember that a child's preference can be persuaded by certain things, like the conflict between the parties. If they're always involved in the conflict and they start feeling bad for one parent against the other, that may influence their preference. Also, bribes. Believe it or not, some parents try to bribe their children to try to spend more time with them. They may offer a new Xbox, a new PlayStation. Many years ago, I had a parent offer the child a brand new pet, a new puppy, in order to try to influence the case when they were about to have an in-camera testimony or an in-camera interview with the judge. Remember also that coaching is frowned upon. If a court finds out that one parent was coaching the child or scaring the child that if they act a certain way or if they say a certain thing, they're going to lose custody and make the child feel bad, that is very much disapproved by the courts, and parents need to be careful about that. Now, for those of you who are a little salty or mad at me from the intro of this video where I made it seem like there might be an age in which a court would consider a testimony of children, a fair question is, what ages carry more weight when they articulate a preference? And typically, at least in my experience, and remember that each case is different, children who are 13 years old and older, between 13 and 17, are the children that the courts may give a little bit more consideration of their preference. But there's no guarantees. Remember, there's no magic number. The more thoughtful, consistent, and independent the children are when they testify or they express their preference to the court, the more persuasive it will be to the judge. All right, before we wrap up this video, I thought we'd discuss some life lessons so that we can end on a positive note. Remember, number one, sometimes a child or children's preference is not about which parent they love more or less. It's about where they feel safe, stable, and heard. That is so important, so when they get home from school or wherever, they feel that safety. They don't feel that stress or anxiety, especially when the parents are fighting during a divorce. Number two, as a parent going through a divorce, your job isn't to be the favorite parent, it is to be the reliable one. Reliability is so important. Being there for all of the milestones, being there for the ups, being there for the downs is so much more important. And finally, number three, consistency wins custody, not flash. You have to be there for the trophies. You have to be there for the field trips. You have to be there when they're sick in the hospital, or if you have to stay up with them till 3 in the morning and not sleep the day before work. That is going to be a compelling case to the most important judge, and that is the children, because children pick up on all of that. That is so much better than a parent who shows up once a month and takes them on some flashy vacation somewhere. Kids are smart. Kids know what true, genuine stability is, and that is something that parents should strive for if they want to be successful in court. All right, that's a wrap on our video discussing whether or not children can choose which parent to live with during divorce. If you know anyone that is going through a similar situation, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Please do us a favor and like this video. Drop a comment below, see how we did today, and subscribe to the Divorce Broadcast. We'll talk to you again very soon. Thank you.